What happens when the IRS sends a letter regarding a deceased foreigner who owned assets in the US? This situation can raise a lot of questions for heirs, attorneys, or executors managing estates across borders. So, we've created this video to walk you through the most frequently asked questions about this topic. Let's get started. Question 1. Why would the IRS send a letter about a deceased foreign person? The IRS sends these letters when a non-US person passes away owning US situs assets, such as real estate in the US stocks or brokerage accounts, business interests, or tangible property in the US. If the value of these assets exceeds $60,000, the estate may owe US estate tax, and the IRS expects a filing, specifically Form 706-NA, the estate tax return for non-resident aliens. Question 2. What types of US assets are subject to estate tax for foreign individuals? The IRS considers the following as US situs assets for estate tax purposes: real estate located in the US, shares in US corporations, tangible personal property in the US, certain business interests connected to the US, cash in US brokerage or investment accounts. Assets held through foreign corporations or trusts may sometimes avoid this rule, but you must have a proper structure in place. Question: what kind of letters or notices might the IRS send? Common IRS notices include CP notices, alerts that a filing is missing or a balance is due. Letter 627 or 12C, requests for more information about an estate return. Letter 2645C indicates the IRS is reviewing the documents. Notice of estate tax determination states the final tax due. Letter 55699 reminds the estate to file a return if it hasn't yet. Question 4. What forms are typically required? The main forms you may need to file are Form 706-NA, the U.S. estate tax return for non-resident aliens. Form 4768, to request an extension. Form SS4, to apply for an EIN for the estate. Form 2848, if someone is representing the estate before the IRS. Form 8971, if you're distributing estate assets to beneficiaries. Question 5. What happens if you ignore the IRS letter? Ignoring the letter could lead to IRS liens on US property, delays in transferring or selling real estate or stocks, frozen bank accounts or blocked asset transfers, penalties and interest for late or non-filing, loss of tax treaty benefits if not claimed properly. Question 6. Can an estate tax treaty reduce the tax due? Yes. The US has estate tax treaties with several countries, including Canada, Germany, UK, France, Japan, Italy, Netherlands, and more. If you qualify, you may be able to claim the same 13 million plus exemption that US citizens get, instead of just $60,000. You must cite the treaty on Form 706-NA and include a legal explanation. Question 7. How long do you have to respond or file? Form 706-NA must be filed within 9 months of the date of death. You can request a 6-month extension using Form 4768. IRS letters typically allow 30 to 60 days to respond depending on the notice. If tax is due, interest and penalties accrue if not paid on time. Question 8. Who is responsible for handling this process? The executor, heirs, legal representative, or tax advisor should determine what US assets were owned, get accurate valuations as of the date of death, file Form 706-NA and claim any treaty benefits, respond to IRS letters on time, pay any estate tax due or request a payment plan if needed. Managing estate tax for a deceased foreigner with US assets can be complex, but you're not alone. At FAS, CPA and Consultants, we help international families, heirs, attorneys, and investors navigate cross-border estate filings, tax compliance, and IRS communications. If you've received a letter from the IRS or you're unsure whether an estate filing is required, reach out to us for guidance. Thanks for watching. See you next time.